Now, our next presenter has been a member of the Australian Federal Police for 27 years and is currently head of the Professional Standards Command. He's worked for the majority of his career in ACT community policing and is a visiting fellow on the nationally acclaimed Management of Serious Crime program. During his career, he's served abroad within the United Nations Civilian Police in Cyprus, the joint international investigation of the Kuta bombing in Bali, and was officer in charge of the Christmas Island Police. Here to talk about the police response to workplace sexual harassment, please join me in welcoming Commander of Professional Standards at the Australian Federal Police, Jason Kennedy.
Before I do start, thank you for the very kind words, and I'd just like to show my respect and acknowledge the traditional custodians on the land on which we meet today. I pay my respect to elders past, present and emerging, and I'd also like to extend that respect to Aboriginal and Torres Strait Islander people who are present here today. Thank you for the opportunity to speak to you today on what is such an important topic which has such a devastating effect on our community. I'd also like to acknowledge Comcare for organising this really important national forum and bringing together government, non-government and the community to better understand what workplace sexual harassment is and how we can all work together to stop it. The topic that I've been asked to present on today is how matters of workplace sexual harassment are managed once reported to the police, and also the importance of where law enforcement, what we expect engagement with our regulators, and where do our jurisdictions overlap and where do the investigations overlap. So really important topic. I think this topic really highlights the fact that not one person or agency can alone stop workplace sexual harassment, and it does require that strategic and holistic approach and everyone working together, including the community. The recent 2020 Respect at Work report by the Australian Human Rights Commission certainly highlighted the need for a holistic approach which leverages others and avoids that duplication. The need for a holistic and collaborative approach is probably best highlighted when we look at the various legislation that applies to workplace sexual harassment. Not only do we have the work health and safety laws, which are policed by the regulators, we've also got the discrimination and equal opportunity laws, which are ordinarily by the Human Rights Commission and the like. We've got workplace relation laws, which involve our unions and civil courts. We have workers' compensation laws, which involve our regulators, compensation insurance and civil courts. And what I'm here to talk about today is where the criminal jurisdiction comes into it, and that can be at a Commonwealth, state and territory level. There's a number of examples of what constitutes workplace sexual harassment, and the definition which is contained under the Sex Discrimination Act really does apply a really good definition, but that definition also extends into a number of various forms, and no doubt you'll be see a lot of these examples. And I think it's important to understand is there's some things that constitute workplace sexual harassment, which may not necessarily constitute a criminal offence, and there are some behaviours which actually do fall into the criminal jurisdiction, and those do include things like sexual assault, stalking, indecent exposures, indecent physical contact, indecent emails, phone calls, text messages, online interactions, threatening to share or even sharing intimate images without consent, and even things like non-consensual touching, hugging, cornering or kissing. So I'll slowly work through those and give you a better understanding of that. I think what's important is to understand that the criminal law does not discriminate whether these incidents occur in the home, the workplace or in the public. And also to better understand that whilst some of the legislation deals with civil matters, police don't have jurisdiction in a civil matter, but we do have jurisdiction in criminal matters. So hence we purely look at criminal offences in that regard. One good thing about if we do, as part of a deterrent effect, we need to show to the community and to workplaces and individuals is that sexual harassment can be a crime, and if you do commit a crime, you can face the consequences. And you'll see here the slide that's on the screen at the moment relates to the current parliamentary inquiry which is occurring in Western Australia regarding the mining industry. And one of the first witnesses in that particular inquiry was the West Australian Police, who gave evidence in regards to the number of people that they have charged for workplace sexual harassment related incidents, and how the West Australian Police are working closely with both government and also the industry in order to make that a safer workplace for females in particular. One of my topics of discussion today is, as I mentioned before, is how matters are reported, or how, once matters are reported to police, how they're managed. A lot of people, I must say, are nervous bringing matters that occur in the workplace to the police because they think that in some sense the workplace should deal with it. But at the same time, is if there is a criminal offence occurring, the police should know about it, and we should be investigating it. For most people, where there is that reluctance, I can assure you that where there's any sexual offending, it's treated very seriously by police, and it's treated very seriously by the courts, and it certainly is a matter that's taken seriously by the community at large. Police have many roles, but one is the detection, investigation and prosecution of offenders. And probably one of the first and foremost things that police have to do when we do receive a report of, say, workplace sexual harassment is not only to identify whether an offence has occurred or not, but it's also we have to determine which jurisdiction the actual incident or the offence occurred. Why is jurisdiction important? Firstly, it identifies which offence is relevant. So also will identify which police service is responsible for investigating that particular item, and it also identifies which court can hear those particular matters. So I know we've got a lot of people from around Australia that are dialed into this today. As you can imagine, here in the ACT, we're somewhat of an island inside New South Wales, and the town of Queanbeyan, which sits in New South Wales, which is somewhat a suburb of Canberra, is an island inside the ACT. So on a daily basis, police here in Canberra are constantly determining whether the offence has occurred in, say, the ACT or New South Wales. And on occasion, it may actually be that the offence may actually sit within the Commonwealth jurisdiction as well. So when we do receive reports, the first thing that we will do is try and determine where the jurisdiction sits as to who actually investigates it, and which legislation we're relying on, what powers of not only search and seizure, but also in regards to prosecution and which court it goes to. Once we determine the jurisdiction and which is the correct police service to investigate it, uniformed police will ordinarily be the first to attend, and in some instances, particularly where it's say serious sexual offending, will be referred to detectives. And most police forces around Australia do have a sexual assault, which are a specialist team in that regard. So in those particular matters, it will be detectives that take on the job. But for matters that may be, say, a common assault, that may remain at that uniform level. So just to let you know. An investigation can take not only weeks, could take months or even longer, and that depends on the amount and also the type of evidence required to complete the investigation. So initially we will take a statement from the victim. That statement has to be consensual. If the victim does not consent to the take or the giving of the statement, police will ordinarily not proceed, because it is a victim-centric process, and the victim is at the centre of that. Here in the ACT and a lot of other jurisdictions, we now have things which we call evidence in chief interviews. So previously, where a victim statement would have been taken on paper, now if it satisfies certain criteria, the offence satisfies certain criteria, I should say, police have the opportunity to now video record the taking of that statement, and that statement can actually be used in evidence in chief, which actually does take away some of the stress for the victim when they're giving evidence in court. So that's a really good process that we got now. What we're looking for in the victim statement, I'll show you shortly what a breakdown of an offence looks like and what the proofs are. One of the key important things, particularly for most sexual related offences, is the issue of consent. And so that's a really important one that ultimately we do rely on the victim to assist us in that regard to prove that. When we do take a statement, we then look and identify for avenues of inquiry in order to identify evidence of corroboration, because really what the courts are looking for is what's some type of corroboration, and that also assists the victim in that regard, because if we just put the victim up in the witness box and no corroborative evidence, the actual defence counsel will, ultimately try and discredit that witness, because that's the basis of the entire brief. So the idea of the investigation is to look at what's reported and then conduct those inquiries, and that includes interviewing witnesses. It also means it may necessarily require search warrants, may see us do digital forensic examinations and the like. And also what's really important as well is, as we're, from the time of the initial report right throughout the investigation, is there's always a consistent assessment of the victim's need for protection as well. Because again, like I said, it's a very victim-centric approach to the way we do it. And the victim and their needs, support needs and their protection is always key to that. In regards to when we go to interview the suspect, quite often we will have investigated the matter and we've collected a lot of evidence. And part of interviewing the suspect is, for some of you will well know, is we have natural justice as part of our legal process here in Australia. And essentially what natural justice is if an allegation is made against someone, they have the right to A, know what the allegation is, and B, they have the opportunity to either rebut or agree with that allegation. So interviewing the suspect is really important in that regard, and quite often the interviewing the suspect will occur after police have already obtained evidence, and part of that interview will be demonstrating to the suspect what evidence exists and give them the opportunity to provide reason for that. At the end of the investigation, police will determine whether an investigation is continued based on not only the circumstances of the offence and what evidence is available. So for each and every criminal offence, there's each offence is broken down into what we call proofs, or you may actually even hear it called elements. So they're called offence proofs or offence elements, but every single offence has these proofs and elements, and the onus on the prosecution, which is the police, is to prove each of those proofs or elements beyond a reasonable doubt. So that's the role of the police, and it's pretty much in our legal system is that he who accuses must prove the offence. So when we look at say a common assault, and this could be something as simple as non-consensual touching or the like. So the first proof or element is that there's a physical element, or it can be non-physical. So it could even be a threat of violence. So there's no actual violence placed on the person, but there could be a threat. So there's case law in regards to what non-physical looks like. Like I mentioned before, where the victim is key is proving without the consent. So we need to be able to prove whether consent was whether it was obvious that there was no consent, or the person just clearly said that they didn't consent to what was going on. We have to prove whether the act itself was intentional or reckless, and we've also got to prove that it was without lawful excuse. Okay, so that just gives you an idea. So when we do complete an investigation, even as we're going along, we're actually looking at the proofs of the offence, and we do what we is called an evidence matrix, and we look at what each of the elements are, and then we place what evidence we have against each of those elements to prove each of those items beyond a reasonable doubt. Also, what's important is for the victim to understand is that they will be informed of the progress of the investigation, unless the disclosure may jeopardise something in the investigation, but there'd have to be pretty good reason for that. We also inform the victim of any charges that are laid against the accused, or the reasons for not laying charges. We also keep the victim informed as if there's any modification to those charges, or if there's any type of, you might hear the case plea bargaining, but the victim is always included in any decisions that are made. What what's really important is to understand that not only will there be a police investigation, but there may well also be a concurrent workplace investigation which is undertaken by a regulator. So WorkSafe is a government organisation responsible for the administration of the legislation for the health, safety and welfare of people at work. WorkSafe inspectors are trained to provide information and advice on workplace health and safety, and they're also trained to enforce compliance of that legislation. So quite often you'll find that the police investigation, the regulators' investigations will intersect where evidence in possession of either party may be relevant to our investigation. So there may be evidence that we have in our investigation which will be relevant to the workplace regulator and vice versa. So that's probably one of the key things is where they intersect. What's really good for us is the regulators have subject matter expertise on workplaces and also workplace compliance, and they can give us advice in regards to what documentation or what certain requirements may be out there. So we do rely heavily on the workplace regulators to assist and guide us on that regard. You'll see the slide in front of you. I've included as a bit of a visual to highlight where our investigations do intersect. So the first one on the bottom left is what you'd probably describe as chaos, where each person or agency is seeking to do their own thing without any thought for others, and no one really gets anywhere. So that's really not where we want to be when we're talking about the police and regulators, working together and concurrent. We actually want a bit of orderly approach, which is, the middle picture talks of that. You can see there's quite an orderly approach, but what that particular picture highlights is that one half of the one agency has to pause while the other one proceeds, and that's not always the best thing in that regard. So whilst there can be orderly, we don't necessarily, either agency doesn't want to be halting the other one from doing their work. The picture on the right, however, highlights that we should be seeking we basically should be seeking to achieve a system where we can all proceed at once without causing unnecessary delays or colliding with each other. So if we're looking at what police and regulators should be aiming for, it would really be up in that top right-hand corner in regards to together. We've each got a role to do, but how do we do it together and how do we leverage off each other's resources to achieve the common objective? And really at the end of the day, that's to prevent workplace sexual harassment. In the ACT, we have an MOU or a Memorandum of Understanding between ACT Policing and WorkSafe ACT, and I'd hope to think that for each of the jurisdictions around the country is that would be the same. The purpose of our Memorandum of Understanding is to facilitate cooperation and collaboration in relation to the conduct of workplace investigations and joint operations. So the good thing for us is we're not we're very used to working with regulators for years. Police and regulators have worked very closely, and probably more so has been in regards to workplace injury and in particular death, where quite often we're investigating, the police may be investigating the death on behalf of the coroner, and the regulator is investigating whether there's breaches of the Work Health and Safety Act, which may have led to that death. So we quite often will work with the regulators, so there's nothing new here, and hence why we do have an MOU. Things to include in an MOU include agency roles, so it's really important for each agency to understand what our roles and responsibilities are. Things like information and intelligence exchange, because like I said before, there'll be documentation which may be in the possession of police or may be in possession of the regulator, which the other party needs. So an MOU provides that legal basis for that. Talks about how we protect personal information, what our communication policy is, where there are any differences, how we resolve those, operational guidelines, and even getting down to the laying of charges and who's responsible for what, even things like media reporting. So my advice would be don't wait for an incident to occur before you develop such an MOU. You'll probably find if you do have an MOU, have a quick look at it. You'll probably find a lot of it is around attendance at workplace injury and death occasions. And it's really time to update that to include things like workplace sexual harassment. Probably the main thing is just to understand is that we as police will work, probably more often than not, we'll be working with a number of agencies. We as police know that we can't do anything alone, and we know that we don't have the resources to do everything by ourselves. So we actually do reach out and we do lean on a lot of people in order to leverage their resources and basically achieve those results together. So I hope that gives you a pretty good explanation of how policing works, but also how we do work hand in glove with our regulators. And I do encourage you to develop an MOU with your local police service if you haven't already done so.
Thank you so much, Jason Kennedy. Really appreciate that update. We'll have some questions coming through in the chat box in a moment. But before that happens, I'd like to ask, how difficult is it to secure corroborative evidence? As you were saying that, I thought, gosh, this is the kind of crime that often happens, you know, behind closed doors in a quiet place without too many witnesses. How hard is that?
Yeah, really what it comes down to is, again, when we take the statement from the victim, is quite often we get really detailed evidence of each of the incidents. So we do go into a lot of detail. At times, the victim may think it's quite obtrusive, but what it does allow us to do is identify where we can actually go and achieve corroborative evidence in that regard. So people like other witnesses, so maybe work colleagues, it may be there may be electronic records, particularly with emails or text messages. So we actually do find now that our digital forensics is a major component in regards to such matters, because quite often there are conversations over social media or text messages, chat rooms and things like that. Even things like corroborative evidence may well be things like DKS or electronic signature into rooms and things like that, which just confirm times, CCTV, you name it, might be forensics. We go to all lengths in order to find corroborative evidence. And what it does do is the more corroborative evidence we find, the stronger the brief is, and more often than not, the victim themselves don't have to give evidence in court, because more often than not, the offender is overwhelmed by the evidence in the brief and will plead guilty.
Thank you, Jason. Another question here. What issue might arise where WHS prosecutes a worker, for example, for failing to take reasonable care that his or her acts or omissions do not adversely affect the health and safety of others, after the police have already prosecuted an alleged offender?
Yeah, well, I think it highlights is that it's not just an individual responsibility, but it's also a workplace responsibility as well. And that really comes back to the culture of the workplace. So if you've got a strong culture that doesn't tolerate this type of behaviour and calls out this behaviour, and I think you quite often see David Morrison's former Chief of Defence, his words used are pretty much that standard you walk past is that standard you accept, which actually does allow workplace sexual harassment to thrive in an organisation. So if it's not only having a workplace policy, but it's also having the leadership to actually drive that policy. So what it does highlight is, yes, whilst an individual may have done that act, is if a workplace hasn't provided that safe environment, then they're also responsible. And I think having that deterrent actually ensures that workplaces do not only have a policy, but they also take the policy seriously, and they also enforce that policy, and they call out those behaviours early, which actually prevent them from becoming offences.
Speaking of leadership, is there any obligation on an employer to report a potential offence to the police? What if the victim has said they don't want to?
Yeah, certainly anyone can report a matter to the police in that regard. There's certainly, unless there's some workplace obligation, certainly I know here in the AFP we have a very, very strong professional standards framework, which actually does have mandatory reporting requirements on our members. And so if they don't report, they actually are subject to a code of conduct breach themselves. But in regards to the criminal law, there's no such mandatory that I'm aware of. There certainly is in regards to things like children. we have some mandatory reporting requirements. But at the same time it could be useful where a employer does come and talk to police, and it could be the case that police reach out to that person, and it may be that they need support or some type of guidance to give them the confidence to come and report it. But at the same time, police can offer advice on a number of occasions. It might be that the employer really doesn't know where to turn, and the police can give that advice, or at least put them in contact with someone who can assist them in that regard.
Okay, are there complications with the company investigating as well as the police? And this question has put an interesting conundrum in there. What are some of the issues if the two investigations have different outcomes?
Yeah, and this is certainly one that we have every day in professional standards here in the AFP. We not only investigate, because we're the police, we not only investigate our own members for criminal allegations, but we also investigate our members for breaches of our code of conduct. And what we do is quite often we'll run a concurrent criminal investigation with a administrative investigation. But the way that we do that is we have to provide a sterile corridor between the two investigations to make sure that evidence that we collect in an administrative investigation, because we have powers under our administrative investigations to be able to direct people to answer questions, whereas in a criminal environment, a person is under no obligation to answer questions. They've got a right to silence. So we cannot use evidence that we collect in an administrative investigation in our criminal investigation, but we can use evidence in our criminal investigation for the administrative investigation. On the same note, is a criminal investigation, the standard of proof is proof beyond a reasonable doubt. And in a civil matter or an administrative workplace investigation, it's on the balance of probability. So it's actually a lesser standard of proof. So quite often, even here in the police, we will have matters where the person may be found not guilty in court, but we will still have established findings against them because they'll have breaches of the code of conduct, which may not necessarily require a breach of law. So that's why sometimes you do get those differences.
Gee, it's a tricky area, isn't it? Okay, final question from Veronica. A lot of the matters I deal with relate to nurses sexually assaulted by patients. Many of these patients may have had some type of cognitive impairment, for example, brain injury, psychosis or dementia. How is this considered when it comes to intent?
Yeah, so I'd encourage, particularly we do go offences of assault on nurses. The fact that a person may have a cognitive impairment, we will still, that's part of the investigation as to whether they had the necessary ability or comprehension to form that intent. At the same time is ultimately it may be up to the court to decide whether they had that necessary intent. So there's also other things that we can do here in the ACT. We have a mental health tribunal. So where a person may have a cognitive impairment, may not necessarily mean that they get away with the incident that's occurred. You can't just have your nurses being assaulted, but there may be other means in order to stop that behaviour, and that may be through various types of treatment orders and the like. But I'd certainly encourage those people to report those matters to police, and that will certainly be part of the investigation. But there is ways and means in which to manage that.
Thank you so much for your time and for sharing your wisdom, Commander Jason Kennedy.